In this section of the course, we're going to talk about jurors and juries. And there are just so many different things that I could talk about with regard to jurors. This is the area of research that I do, and I've published lots on juries and jury decision making. So it took me a while to kind of pare this down so that I didn't have a whole class on juries. So bear with me. Let's take a look before we talk about any of the research or any of the relevance to psychology and law. Let's take a look at how we select jurors in this country. The first thing we need to look at is what's called the veneer. The veneer is a panel of jurors that are picked for a specific period of time. So they're a panel that are chosen from a pool. Now, who's the pool? The pool technically is anybody, for example, in the state of Wyoming that's over the age of 18. Technically, they're the pool. In reality, each state has to define that pool. Like, how do you figure out who is eligible to be on a veneer? Well, in many states, if you register to vote, then you become part of the pool. In Wyoming, when you get a Wyoming driver's license, you're part of the pool. So the veneer then is a group of people that are picked from the pool. And some of you may have actually gotten letters in your past saying that you are now part of a veneer. They may not have used the term veneer, but you're picked for a period of time. So for example, they might say that for the next 6 months, you might be picked for any particular jury, and they might ask you to fill out a form to see whether or not you're qualified. The Supreme Court, since the 80s, has been trying to encourage representativeness of this veneer, of this potential group of people. Before then, the way that we kind of found jurors, we go into town and look for unemployed men that were hanging around that day, or there might be a panel of people who are upstanding community members, but since the 80s, the pool has to be much more representative. Now, there are some people who can be excused from the pool. Firefighters, for example, once you get that letter, you usually have to fill something out. And there are certain things that can excuse you from the pool. Firefighters, police officers, if you're the sole proprietor of a business, you can be excused. Up until 1979, women could get an automatic exemption if they had children. And before 1979, only 15% of the juries had women on them. And so the court finally had to say, no, even if you have children, you might have to serve on a jury. And after that, you saw the number of women serving on juries rose pretty exponentially. So there are some people who are excused, but the courts are very picky about who they excuse. So now that you're in a veneer, let's say you're in a veneer, how do you get seated on a jury? Well, what happens is you will get a letter or you will get contacted in some way to take part in what's called a veneer, a voir dire, excuse me. A voir dire is when we take people from the veneer. So if we need to seat 12 people, we may ask 30 people to come in. And what we'll do is conduct a voir dire, which is choosing the jurors that will actually serve in a particular trial. So let's take a look at the voir dire process. In the voir dire process, potential jurors are brought into the courtroom and they are asked certain questions. And the questions that are being asked are designed to assess whether or not a particular person can be fair. Now, there are two ways in which a juror could be struck or a person could be struck from the jury. One is what's called a peremptory challenge. And a peremptory challenge is a challenge that an attorney uses. It could be the prosecutor or the defense. And they simply, for some reason, don't want you on the jury, for some reason. And they don't typically have to explain what reason it is. So they can just simply not like the look of you, think that you might judge them too severely, and so they can strike you. You can't strike solely on the base of race. So if you're trying to strike all the African Americans during the voir dire process, At first, you may not have to give a reason, but if the judge starts noticing that all the African Americans are being challenged, you're going to be asked to give an explanation. Now, the number of peremptory challenges that an attorney has in any given case is usually determined by statute or by the judge. In very high-profile cases, attorneys typically have more peremptory challenges. In more mundane cases, probably statute or a judge will restrict the number of peremptory challenges. So an attorney will know how many peremptory challenges he or she has and will use them to strike jurors that they don't think are going to be sympathetic to their case. Now, during this voir dire process, attorneys really try to seek people that will be sympathetic to their case. And so they use what we call implicit theories about who to strike. Implicit theories are these theories that people have that they're not taught, but they have these ideas in their mind about who is not going to be sympathetic to their case. Just to give you some funny examples, from this very old trial tactics textbook, law students were told things like this. They were told that Irish jurors could forgive intoxication more easily than an Italian. So if you had a DWI case and you were the defense, you tried to seek the Irish jurors. Another thing that attorneys were told, smiling jurors are trying to disarm the attorney. They want to get on the jury and then murder you. Here's another good one. Persons of superior intelligence should be avoided. Another one. Presbyterians are too cold for criminal defense. Baptists are worse. Methodists might be considered. So you can see that these are kind of implicit ideas about how generally the public will act. But making those decisions is very important for most attorneys. And even today, how to conduct a voir dire, who to strike and who to keep can be very important to attorneys. So here's a short video from a district attorney talking about who you should keep and who you should strike on a jury. And it sounds a little bit like
to get a competent, fair, and impartial jury. Well, that's ridiculous. You're there to win. And in order to win, and the defense is there to win too, and the only way you're going to do your best is to get jurors that are as unfair and more likely to convict than anybody else in that room. Let's face it again. There's the blacks from the low-income areas are less likely to convict. And as a result, you don't want those people on your jury. And it may appear as if you're being racist or whatnot, but again, you're just being realistic. You're just trying to win the case. You don't want smart people, because smart people will analyze the hell out of your case. They have a higher standard. They hold you up to a higher standard. They hold the courts up to a higher standard because they're intelligent people. They take those words reasonable doubt and they actually try to think about them. And you don't want those people.
Yes, can you imagine actually thinking about reasonable doubt? You just certainly don't want those people. So you can see that attorneys take this very seriously. And this district attorney obviously is looking for a guilty plea, so he's wanting to strike certain people that aren't likely to vote guilty. Now, attorneys have peremptory challenges, but I also want to mention that they have also what's called challenges for cause. Challenges for cause are very different. Obviously, there are statutory requirements that a juror has to be unbiased and be able to render a fair verdict. So challenges for cause is the ability to dismiss potential jurors who have a bias. Okay. Now this bias could be a general bias. So for example, if you had a civil case where a writer was suing a publisher, you might argue that writers probably shouldn't be on the jury, that they might have some general bias for the writer in the case and against the publisher. Or you might have specific bias, so that you might be related to somebody that's on the case. If your brother-in-law is on the case, that would be a specific bias. So challenges for cause can happen anytime, and there's no limit on the number of challenges for cause, because you want to make sure that you have a fair jury, and if there are biased jurors, you should be able to strike them. So there isn't really any limit. Of course, you'll have to tell the judge why you're um, dismissing them, and the judge will have to agree. So challenges for cause and peremptory challenges. Now, during this voir dire process, then you question jurors, potential jurors, use your challenges, and then finally you have a jury that you're going to seat. Okay? So I've talked about fairness a little bit, but there's a question, does fairness or impartial mean uninformed? Now, this becomes particularly important in very high profile cases. So, for example, many years ago now, there was a very famous case that was the Rodney King beating, where Rodney King was a motorist. He was pulled over by police officers and beaten um, by a group of police officers. He was African American, and the 4 police officers were white. The entire beating was captured on videotape. And what happened was it was played over and over and over and over in the news. I mean, morning, noon, and night, you saw excerpts from the Rodney King beating. So now fast forward, you come to trial, and the question is a juror who has seen that video biased or unbiased? Well, in this particular case, the judge ruled that they could only seat jurors who had not seen that videotape. So if you think about it, at the time, who were the people that would not have seen that videotape? They would have had to have been hiding in a cave someplace. And so the question is that the right jury to seat? So in these high profile cases, some of these issues come into play. Okay, so the goal of seating a jury, of course, is to seat an unbiased jury, in theory. In reality, as you know, the attorneys are trying to seat, as that one district attorney told you point blank, in reality, what they're trying to do is influence the jury composition and get people who are sympathetic to them. One study that looked at the voir dire process that found that, depending on the attorney, they spent 40 to 80% of their voir dire time trying to persuade the jury panel to be sympathetic to them. So what they're trying to do is look for people who seem like they're going to be sympathetic, perhaps nod when you're talking or whatever. So voir dire, then, in theory, let's seat some unbiased juries. In reality, they're trying to push the limit. Now, I should mention also that when I'm talking about the voir dire and the questioning, it depends on the court that you're in terms of the questions. In the local courts, mostly attorneys run the voir dire, so they ask the questions. In the federal courts, the judge might likely ask the questions of the jurors. And of course, the attorneys can submit some questions and they can challenge, but it's usually the judge that does this. Okay? So now we've got a good idea of how we select juries. Now let's talk about how psychology and law, or how psychology plays into this. And these are some of the questions that we're going to be looking at in this section of the course. For example, are there certain kinds of individuals that are more conviction prone? So they're more likely to convict than other people. Are jurors biased, and when? How do jurors process information at trial? How do they come up with their verdicts? Deliberation. Does deliberation lead to a better or worse outcome? Is it good that people have to talk before they come up with a verdict, or would it be just as well just to vote and be done with it? And how do experts impact juror and jury decisions? So these are some of the topics that we're going to be covering in the upcoming lectures. But let me just end this lecture by telling you about one study that looks at bias. Let's take a look at juror bias. Now, one type of bias that we talk about in the second law literature is what we call an extra-legal factor. Extra-legal factor is an irrelevant piece of information about the defendant and their background or appearance. This is information that should not affect your decision-making, but might actually affect decision-making. Factors that are extra-legal factors are things like gender. Whether a male or female commits the crime shouldn't make any difference. The race of the defendant shouldn't make any difference. The social class of the defendant shouldn't make any difference. Um, Defendant attractiveness shouldn't make any difference. These are all extra legal factors that shouldn't come into play, but we found come into play when people make their decisions. One last factor I want to mention, and I put a question mark behind it, is age an extra legal factor? Well, I think you could say that in some cases it is an extra legal factor, and in other cases it's not. If you recall that when we talked about eyewitness memory, age of the eyewitness is really an important variable in terms of how reliable it's likely to be. So if you have a 3-year-old or if you have a very elderly person in their 80s, they tend to make more mistakes in identifying witnesses. So if you have a victim that's very old or very young, age might not actually be an extra legal factor. It might actually be relevant to the case. So I guess I would say age can be an extra legal factor, but it might actually be a relevant factor. Other kinds of extra legal factors is things like information from other sources. So when you read something in the newspaper or you watch it on the TV, you're not supposed to let that information bias you, but we're going to be talking about that a little bit. In fact, it may. So before I end, let me tell you about a study that we did quite a few years ago now that looked at extra legal factors. In this particular study, we looked at perceptions of juvenile offenders. And this was a study of a juvenile offender who was tried as an adult. And what we were looking at is whether the sex of the defendant impacted jury verdicts from pre to post deliberations. There had been some studies that looked at juveniles who were waived to adult courts, but they mostly focused on male juveniles, and no one had really looked at females. Another factor that we looked at in the study is how mitigating factors, such as abuse history, might impact jurors' verdicts pre to post deliberation. So obviously you can tell from my use of pre and post deliberation, we asked people to give their opinions before they deliberated and then again afterwards, looking at whether or not deliberation changes things a bit. So let me tell you a little bit about the study. We had 674 mock jurors, and the case that we used was based on a 1984 case in Wyoming, Janke versus Wyoming. In this particular case, this is a juvenile male who was accused of murdering his father in Cheyenne. And what happened was Janke hid weapons throughout the house, put weapons in different parts of the house. And he also put his dog in the bathroom and locked his dog in the bathroom, and then sat in the garage and waited for his stepfather to return. And when his stepfather returned and opened the garage door, Janke fired several shots and killed his stepfather. Now, during the trial, it was brought up that Janke had suffered from severe abuse throughout his life, and he had kind of snapped and was going to kill his stepfather. The reason why he hid guns all over the house is he was afraid that he wouldn't get the job done in the garage and then run to the kitchen and grab another weapon and so forth and so on. This particular trial, the Janke trial, was designed, and it was a classic first or second degree murder trial. There seemed to be intent. The fact that he hid his dog in a bathroom to keep him safe suggests intent. And without the mitigating factors, you're probably looking at a pretty strong, actually, first degree murder trial and maybe second degree murder trial. So we used this trial, and of course we varied the abuse history, whether or not there was abuse or not. The actual trial there was abuse, but we varied the abuse history and whether the defendant was a male or female. Okay, so as you can see, abuse history is not an extra legal factor; it's actually a mitigating factor. And sex of the defendant is an extra legal factor because sex shouldn't make any difference. So what did we find? First, let me show you just the main effect of sex, okay, or gender. So here's what we found. What you can see, if you look at the pre-deliberation verdicts, by the way, if these letters here indicate that these were not significantly different from one another. So if it's the same letter, it means it's not significantly different. So as you can see, pre-deliberation, there's no significant difference between the males and the females. The verdicts were, oh, by the way, I think I need to mention, 1 through 4, the potential verdicts were, not guilty, self-defense, manslaughter, second degree, first degree. So higher numbers mean harsher verdicts. Okay, so just need to orient you to that. So higher numbers indicate more severe verdicts. And so what you have here is you can see that pre-deliberation, there was no difference. But post-deliberation, you saw that females were treated significantly more harshly. So after people got a chance to talk with one another, they tended to be more harsh than prior to deliberations, which suggests that they're being influenced by an extra legal factor of gender. Now let's take a look at the results for abuse and sex and verdict, so the three-way interaction. So here's what you have here. Now let me orient you here. As you can see, the non-abused male in the non-abuse condition, okay, when there was no abuse, pre-deliberation to post-deliberation, people got more, the verdicts became more severe. So if you look here, pre-deliberation, virtually no difference between male and female, but post-deliberation, for both males and females, they became more severe. So we're not alleging any abuse history, and after deliberation, people are feeling a little bit more punitive. But you can see that this is particularly true for the female. Okay, this is particularly true. Again, kind of like what we saw before. Now let's look at this abuse condition. What you see here is that when you're alleging that the child has been abused, okay, what you see is pre-deliberation already, they tend to be a little bit more harsh for the female and then way more harsh after deliberation. Whereas you don't see that same jump for males. So what seems to be happening here is that they're treating males and females differently, which doesn't really make sense because there's not any logical or legal reason why you should treat males and females different. So that suggests that there's some beliefs about males and females that affect people's decisions in cases like this. So in conclusion, as far as this particular study goes, male and female juveniles were treated differently. The mock jurors were much harsher with females, and the mitigating factor of abuse was more important for males than it was for females. And again, this suggests that there were some biases playing into jurors' decision making. Now, we don't know exactly what those biases are. Perhaps people think that girls who kill are more dangerous or untreatable than boys that kill, especially if there's abuse. Those are all the questions that we tend to ask afterwards in subsequent studies to try to figure out why the biases exist. But you can see here that there is a bias. We just don't know what it is at this point. Okay? So that gives you a flavor of what we're going to be talking about here in this next section, and we'll continue this discussion in our next lecture. Thank you.